Hello and welcome to another episode of Buzaker Law Firm podcast. Hello, Valeria Buzaker.
Hi, how are you?
I'm good, thank you. How are you?
Amazing.
We'll start talking business in 10 seconds, just after that.
The disclaimer, the information provided in this series does not and is not intended to constitute legal advice. Instead, all information is for general information purposes only.
Thanks, Valeria. That was 10 seconds short, by the way. In this episode, we are going to continue to discuss the disposal of your business due to various reasons. Valeria, hi again. Could you please explain?
So, hi everyone. Today we'll talk about different aspects of disposal of your business and the disposal which is imposed on the entrepreneur for external reasons.
I think that it is important to say at this stage already that the bottom line of this episode is that even when worst comes to worst, there's always hope. That's important to remember. But let me ask you the first question. When you say disposal of your business involuntarily, you probably mean bankruptcy. So maybe we should explain first what bankruptcy actually is.
Yeah, so bankruptcy is in accordance to the Bankruptcy and Insolvency Act. A bankrupt is an insolvent person or a corporation. In other words, it's a person whose total liabilities outweigh its assets, meaning that the company or the person cannot pay its due debts. They're outstanding debts and the company or the person cannot pay them. So we are talking about main consequences of the bankruptcy. Just to give you an idea, obviously we cannot cover everything in this episode, so we'll just give you some idea of how it looks like. What does it mean for you being bankrupt? So being bankrupt means that there will be a drop of your credit score. So if you're first time being bankrupt, it will be for 6 years following the first bankruptcy. If you are second time bankrupt, it will be following the second bankruptcy for 14 years, which is very important if you're considering, for example, getting a mortgage. Credit score is a very, very important issue. There will be loss of assets. So loss of assets means that all your assets will be turned to the insolvency trustee. The insolvency trustee will realize them and distribute them, all the proceeds of those assets among all the creditors, which means those assets are no longer yours. And the trustee will have the right to do what is correct in these certain circumstances. The other thing which is important to remember is the protection from the creditors. So it's actually some sort of a positive thing in this scenario because it means that it won't be so chaotic as opposed to all the creditors just coming to you and asking for money. It will be centralized and realized in one kind of collective procedure, and it will organize all your assets and debts, and it will work with the creditors. The other important thing that you have to remember is that the company directors can also be held liable if they didn't remit the source deductions, such as HST, CPP, and being a director, as we mentioned in our previous episode about the corporation, there are certain liabilities, and this is one of them.
And as always, a good legal advice could make a huge difference.
Yes, with the right legal advice, things can be done to minimize as much as possible the losses.
Yeah. And could you please elaborate on this?
So, sure. A state of insolvency doesn't necessarily mean that the business is bankrupt. Often it means that the business is suffering temporary cash flow or difficulty, while the business model is in general a good business model and it's profitable. So in this case, one of the options is to draft a consumer proposal. Consumer proposal is a proposal to the creditors. In this case, you can undertake to pay only part of the debt, while the rest will be written off.
That's interesting. Why would they agree to receive less than they deserve?
So it's not receiving less than they deserve. It means that they are getting something rather than nothing. Mm-hmm. So to have $1 today is better than having $2 sometimes in the indefinite future. Sometimes vendor will prefer to write off the part of the debt because they want to continue in working with this business and they want to know that some of this debt was paid, but they were very happy with the services of this company and they don't want to completely stop their relationship.
And what if the creditors don't accept the proposal? What happens then?
So unfortunately, it happens. And we have to remember our previous episode. Hopefully you listen to it. And if not, you're welcome to do it right now. We discussed in our previous episode about how to sell your business. And this way, by selling your business, you are avoiding the bankruptcy process. So you don't have to be accepted or not accepted under this proposal, which means that, for example, if you are selling your assets of your corporation only, it means that the body of the corporation is still left. And if it's left, it means that you are applying for taxes on an annual basis and you are applying for annuals to Corporations Canada if you're a federal corporation. It's very important to understand that the fact that you sold all the assets of the corporation, it doesn't mean that the company does not exist anymore. It does. Which means that in order to get rid of this corporation, you will have to dissolve your company, which means to stop from existing. In order to do so, you have to apply for the certificate of dissolution.
Is it possible to initiate the process earlier when the owner is still in the midst of selling the assets, or even in the beginning?
Yes, for sure. The corporation can start the dissolution process before the liquidation process. In this case, the corporation can apply for the certificate of intent to dissolve. The certificate of intent to dissolve serves a public notice of the corporation, and it means that the company is no longer carrying on its activities except to the extent necessary for the liquidation process. When the certificate of intent to dissolve is issued, the corporation must cease to operate its regular activity. It's very important to be aware of.
And it's important to distinguish here between a business that's registered in Canada and a business that's registered in Ontario.
Correct. Or in any other province. We have to remember that the information, as we say always, is very general, and the information I provided just now is only in accordance to Canada Business Corporation Act. The process is very different in every province and whether you're doing it provincially or federally.
And to conclude these two episodes about the end of the life cycle of a business, it's important to say again that even when everything seems to be lost, there's always something to do.
Oh, for sure. I hope I opened your eyes and gave you some ideas as to how you can actually start from beginning and not necessarily thinking about the end. Everything is the future.
Valeria Buzaker of Buzaker Law Firm, thank you very much for this episode.
Thank you very much. It was a pleasure, and good luck, everyone.
Before we depart, let's just remind everybody how it is possible to interact with the podcast.
For sure.
Yeah.
Please don't forget to leave us your feedback on our YouTube channel, comments, as well as on our info@vblegal.ca, info@vblegal.ca.
Thanks, Valeria. See you next time.
See you next episode. Bye-bye.